Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. This has to do with the summons to appear in court. Let's see here. I've been separated from my wife for a year. 6 months ago, I went to her daughter's 12th birthday party. After that, I received a citation for having touched her improperly. What should I do? That's really odd, because usually when somebody gets charged with a lewd and lascivious acts with a minor, which is a violation of California Penal Code Section 288, parentheses A, you're not going to get a little ticket. You're going to have a police officer come and try to ask you questions and physically arrest you, potentially. That's really strange. Well, number one, what should you do is be quiet. Don't talk to the police for any reason whatsoever, because anything you say or do will be used against you in court. Doesn't matter if you're innocent. Never talk to the police, because you might accidentally admit to something that you didn't realize was a crime, that in fact is a crime. So just don't say anything. Remember, silence is golden, especially here in the criminal justice system. Now, the attorney who represents you is going to have to go to court, is going to have to enter pleas of not guilty, is going to have to order copies of the police report and all the physical evidence. Then the judge will have to give a new court date to come back and start discussing the matter with the DA's office. It's very possible that a private investigator will have to be introduced into the case to speak to witnesses, maybe even the victim, to see if there are any inconsistent statements from what was told to the police. At a certain point, a determination has to be made as to whether or not the case has enough credibility or not. Usually at a preliminary hearing where a judge can essentially determine whether or not the case essentially has legs or merit. Now, obviously, if the case seems to have very high merit, maybe it might not be a good idea to take your case to a jury trial where 12 people from the community would listen to all the evidence and they would decide based on that evidence if you're innocent or guilty. Obviously, if the evidence is garbage, well then yeah, go to trial so that you can get your matter dismissed. But all this really needs to be studied. Your attorney really needs to look at a case like this very seriously and very carefully, because not only does this carry up to 8 years in state prison, but it would also require you to have to register as a sex offender for life here in the state of California under Penal Code Section 290. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, give us a call for free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to discuss how to obtain info if somebody is in jail. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.